Hello, good morning. So I'm just setting up my Facebook Live and all my social media platform. Then we're gonna start. Thank you, guys. Okay, so while I'm preparing for our session today to start, if you have some questions that are related to U.S. immigration, can you just write them down in the comment section below, and then I'm gonna try to answer them as much as I can. So again, you could actually start now writing down your queries below. If you could basically, so I actually saw some comments from some bales. Thank you po, pero naka-Facebook user kayo. If you could just identify your location so I know who I am speaking with or presenting to, can you just identify yourselves? So I have 34 now on the Facebook Live, and we will be starting in 2 minutes or 3 minutes. Hello po. Okay, guys. Good morning. This good morning here in New York City. Good evening in the Philippines. And it's been a while since I haven't had the Facebook Live. We just moved into our new office, still here in Queens Boulevard, and we are ready to start doing business here in our new office. Okay, so the intention for today is basically for me to answer open topic questions related to US immigration. So if you actually notice in the past, whenever I have a specific if I had a Facebook Live that is very specific to a topic, then I normally don't entertain questions outside of that topic, just to be fair for everybody who waited for that. But today is to actually give opportunity for others to ask questions, general questions, because today is an open topic conversation about U.S. immigration. Hi, Liano. How many years po pwedeng maka-apply ng green card? H1B po visa holder po ako. Okay, very good question. Na. So, hi Leah. So, it really depends though on the H1B policy. So, if your employer actually is interested to filing your or starting the filing the green card on your first day at work, then they could basically. So, the green card process takes long. It normally takes about 2 years for non-schedule A profession. So, when you say Schedule A, it only refers to nurses and physical therapists. Other than that, then you have to go through the labor certification process, which could take about 2 years. And as a matter of fact, for our clients who actually had chosen to start the immigration process for employment based on the H1 visa, we recommend to them that we're going to start the green card application right away. This is to avoid renewing the H1, no? Especially if the H1 is initially given in 3 years, because the H1 process is more expensive. So we would actually rather encourage them to start the green card because it's a lot cheaper in the long term. So again, just to summarize my question, it really depends on your company policy if they're gonna start your green card application right away. So there are companies who would want to um, let you stay on the H for a while, just to actually see how you work, how your performance is, and then they would decide to start your green card application. So That's the general decision-making process for most employers. Okay, so naka-Facebook user yung iba, no? So hindi ko na mag-read yung specific names. But thank you for watching now. Johanna, is Choice Program Private Christian School exempted sa H-1B? So, Choice Program Private Christian. So, generally, private employers are not eligible for H-1B cap exemption, but there are some very few institutions that could, but it would actually take a lot more conversation. So, if it is a school in the school industry, so chances are medyo malabo, no? So, generally, most of our clients on the H-1B cap exemption program involves public schools. So, if you are working on a private school, chances are they are not. But again, if you really would want to discuss that further, we could set up a conversation with your employer to really know if they would qualify or not for the cap exemption. Kilo po, ilang years po ang processing ng F4? Well, it depends on... Give me a second, ha? Nawala ako. Sorry guys, nawala ako sa screen. Nawala yung screen ko sa live. I'm sorry, I have to stop. I have to restart my streaming because nawala yung streaming ko. I really am so sorry. Oh, here you go. I'm sorry for that one. So it really depends kung where you are now, no? So generally speaking, if you are an F4 derivative visa holder, sibling visas would actually take about 23 years. So ang tagal nun, no? So that's why people are being discouraged to actually file for family-based F4 category kasi nga ang tagal ng paghihintay nun. And there is no way, the only way to expedite that is kung kunwari you're already on yung visa validity, visa number mo is nasa 6 months na, magka-current na siya, then you could basically expedite that by reason of whether the beneficiary or some of the petitioner or some of the beneficiaries have some serious health conditions. Medyo na-off lang ako nung nawala yung screen ko. Give me a second. My friend Joan teacher is planning to move to Canada and get citizenship there, then return to the US eventually without fulfilling the 2-year in the Philippines. Is that possible po? Okay, so this is very tricky. No, kasi having citizenship in other country doesn't exempt you from getting the 2-year home residency requirement. So ibig sabihin nun, kung former J1 teacher siya and subject to the 212E, the general rule is that you have to comply with your 2-year home residency either from your home country, which in that case, the Philippines, or the last country of residence. So halimbawa, nakuha mo yung J1 mo from Thailand, then you have the option of completing your 2-year requirements in Thailand. Now, you become a Canadian citizen, then you want to come into the United States. So then you have the option of actually getting a TN visa. So the TN visa basically is a privilege by virtue of the partnership between the US and Canada and Mexico to actually give some privileges for their Canadian and Mexican citizens to be able to temporarily work in the United States. So the question is, can they avail of that? Possibly, but the moment that you decide to apply for the green card, then lalabas pa rin yung requirement na have you complied with the 2-year home residency requirement. So, if the question is, kung Canadian citizen ako, pwede pa ba ako mag J1 visa? I don't think so. You have to complete with the 2-year home residency requirement. The only possibility is you get the TN visa, and then you might be able to be granted initial non-immigrant TN visa, but that's very limited. The moment that your employer decide to transition you from TN to green card, then lalabas pa rin yung 2-year home residency requirement mo na issue. Michelle, can green card holder be able to sponsor parents? No. You have to be a citizen to be able to petition for parents. Cleto, can we renew our J1 visa here in the United States? So, the appropriate term is basically extend. No? So, your J1 sponsor could basically extend your J1 validity in the United States, but you cannot obtain a visa because visas generally are only issued by the US embassies abroad. So, for J1 visa holders, ang nagiging basihan lang talaga ng lawful stay mo is your DS 2019. So, kung ang DS 2019 mo is about to expire, normally your J1 sponsor will extend your DS 2019. And if ever you'll be asked the proof of your lawful status in the United States, then you could basically show them a copy of your DS 2019 na extended na yung validity period. But visas generally can only be obtained outside the United States. So, magkaiba yung visa stamp mo at saka yung DS 2019. May gabi kasal ko diha sa US pero ni uli ko Pinas. Okay, so I will just translate this now for the benefit of the non-Visayan speaking audience. Okay, so kasal ka na sa US pero umuwi ka ng Philippines in 2018 and you didn't come back. You have not heard anymore from your spouse, then you receive an email that your green card was being abandoned. Yeah, so for people who actually have applied for their green card application in the United States and you left the country without an approved travel permit, then you leaving the United States actually results to abandonment of your green card application. Now, if you no longer are connected to your husband, then you cannot come back and you cannot revive the green card application on your own because this is a family-based petition. So, I really hope that you will be able to be reconnected to your husband because there are cases, I've had cases like that they haven't been talking for each other for X number of years, but then the relationship rekindled and they decide to actually discuss starting the green card process again. But I am not so sure if you have incurred unlawful presence. My recommendation is you consult with an immigration attorney to assess if you are banned from coming back to the United States because of unlawful presence or any grounds of denial, and then good luck on that then. But I really recommend that you consult an immigration attorney to specifically discuss your case. Good morning po. Approve petition po ako. May welcome letter po sa akin, pero may petition po is my dad, pero patay na po siya. Sorry to hear about your loss. So, the general rule is when the petitioner dies, the petition dies with the petitioner. But there is what we call humanitarian reinstatement. So, if the beneficiary is outside the United States, medyo mahirap mababa yung chance of approving the humanitarian reinstatement. But if the beneficiary is in the United States, then there is a 95-98% chance that it can be revived. There is no published processing time for humanitarian reinstatement. So, go online and research about humanitarian reinstatement. So, you could basically do that application on your own. Specific naman yung mga grounds that you could basically use to be able to get reinstatement, but good luck on that. So just one tip though, once you decide to file the humanitarian reinstatement, you have to file it to the office that approve your I-130. So ibig sabihin, if it was the office in Nebraska or in Texas, then you have to send the request to the office that approve your petition. GM, may EB3 unskilled petition po ako na. Nakapasa na po ako sa employer's interview but waiting po ako sa prevailing wage determination. okay lang po ba tatanggap mo na ako ng H-1B visa status? Makapekto po ba? No. So I'm this is an interesting situation though, because EB3 unskilled petition. So basically, you're not talking about professional positions, right? So again, this actually involves other positions that doesn't require at least a bachelor's degree. No, so for as long as you have a 2 years relevant experience to that position offered to you. Then you talk about the H1B, and H1B is a specialty occupation. So a general manager cannot qualify for an H1B application, right? But just to answer the question, pwede ba ako mag-H1B kahit may pending akong AB3? Yes, because the H1B is a dual intent visa, meaning hindi magiging ground ng denial ng green card mo simply because you have an H1B application. In contrary, halimbawa, kung meron kang nag-a-apply ka ng student visa, then you also have a pending EB3, din madideny yung student visa mo because it means meron ka ng intention na magstay dito permanently. So that is not the case for H1B and EB3. So the two visa applications can coexist. So for as long as you qualify for your H1B then. So good luck on that, GM. Hi, Miss Zimi. Oh, hello ma'am from South Carolina. Good morning po. Gracie, ask ko lang yung parents ko, may resident visa sila noon. Then umuwi ng Pinas, ayun, na-expire na yung visa nila. What should I do? Okay, so it really depends on bakit sila hindi nakabalik. No? So let's just say, and again, I need more information here. The general rule is, if you are a green card holder and you left the United States for 1 year or more without an approved re-entry permit, then automatically abandoned or canceled yung permanent resident status mo. So, but if you would be able to prove to the government that you did not intend to abandon your U.S. residence, and the only reason na hindi ka nakabalik are factors beyond your control. Example, nung nagka-pandemic, di ba? Restricted yung travels back to the United States. Then we already have a lot of cases where we were able to get their green card back. The appropriate remedy mo is basically applying for the returning resident visa. So again, I don't know the reason bakit hindi nakabalik agad yung parents mo, but if they actually fall into what I actually previously explained, na the only reason na hindi sila nakabalik are reasons beyond their control, just like the pandemic, then they might be able to come back using the returning resident visa. But if that is not possible and you are a US citizen, I would recommend you can refile the petition for them, because it will only take about 1 year anyway, right? So choose your options there. But if you would want to discuss more on that, I would recommend that you consult an immigration attorney. Hello, Alvin Lim. Hello po. Tans Talakoy. Nag-PM po ako. Boss, I would really recommend that people who would actually send me messages not to send my personal inbox, because I really don't have time to go through my personal inbox. So I would recommend that when you send messages, you would use the iDream America account, because we have specific person assigned to that account to review inquiries. And if you are interested, then my staff would actually assist you in setting up an appointments. No, so I am in meetings all the time, or if I'm not in meetings all the time, I'm actually working on cases. So that's why I assign someone to review inquiries, and that's why I also am not able to respond to private messages most of the time. Diviana, good morning. Pwede na daw bang mag-apply ng tourist visa kung makauwi na under J1 visa? So depends. Kung you are subject to the kukuha lang advance pero di pa daw gagamitin dahil may 2 year. No, so this is paano ba sagutin to, right? Okay, so when you are a J1 visa holder, even if you are in the United States, some people would apply for a change of status from J1 to a tourist visa. And generally speaking, it's a lot easier to get a change status. So halimbawa, yung mga other visa holder, it could be an F1, gusto mag-revert back to a tourist visa, it's a lot easier to change status in the United States. mas mahirap kumuha ng visa outside. So, hindi yung going through the interview process ng US Embassy. So, if you are already a visa holder and you are subject to the 212E, it's really difficult to get an approval of a tourist visa application because the 2-year home residence requirement is really a restriction limitation on your part that really encourages you to stay in your home country and comply with the 2 years so that you have more option coming back to the United States, either on a tourist visa or a working visa or even the immigrant visa. Now, if gagamitin mo kasi yon, it's basically just circumventing that restriction, di ba, na yung 2 year na, okay, stay ka muna dyan, kumpituhin mo muna yung 2 years mo, then come back to the US. So, personally, in my opinion, it will be hard for you to get a tourist visa approved if you are subject to the 212E. Hello, taga Cebu. Mga proud Bisaya here, okay? I wish I could visit Cebu. I think visited Cebu twice only. Gladys, I'm on my second year J1 as public school in Illinois and interesado po ang principal ko mag-offer ng H1B. I told him that the best way is to talk to the governor or senate or congress and state to help me obtain a waiver. Ang sabi po niya is willing daw po siya gawin. Question niya, ano po ba dapat ang process? So, una, you only resort to congressional assistance though when there are no other remedies. Okay? So, if you are a J1 visa holder, there are other establish options for you to obtain a waiver. So there is the no objection statement, there is the exceptional hardship, there is persecution, maraming grounds yan. But if what you're saying is, wala akong ganun then talking to a congressman or senator or congressman doesn't help you. Kasi these processes are established and provided by law. So if you are referring to the interested government agency, and if you are a teacher, then your only government agency that will be possible to file a waiver for you is the Department of Education, which currently they are not accepting. Or if your school is part of that tribal education system, then your government agency is the Bureau of Indian Education. So again, I think I published that in one of my posts before. If, again, the Department of US Education now is not accepting waivers, but there is one state that accepts at least entertaining the interested government agency for Indian tribal education. So this is the BIE, but it's even very difficult though. So ang guidance ko is if your school district is interested to go to that route of the interested government agency, first talk to your HR. If your HR is interested to help you out, then call your local Bureau of Indian Education office. If they are interested, then you could call out a lawyer. Then the lawyer will help you with the paperwork, with the arguments, and at least guide them on what to do. Consulting a lawyer immediately would not help because ang hirap kausap ang taga Bureau of Indian Education. So it's been years since they haven't been accepting IJA waivers, but at least they are opening that now. So I hope I answered that question. Wila, after ka I would say student visa, you went back to Pinas within the required date. Makabalik pa ka or mag-apply ulit ng visa. So again, so if you are a former student visa holder and you have not violated the terms of your visa, if the question is, can I apply? Yeah, of course you can apply. The chance of approval really depends on so many things, right? So if you're trying to apply for another tourist visa, then your case is not different from any other people who are applying for a tourist visa. But then again, if you have not violated the terms of your visa while on student visa, chances are you might be given the tourist visa. But if the records show that you have violated the terms of your visa, then it is a different story. So again, to answer this question, yes, you could come back. But the second question is, will you be approved? Really depends on so many things. So good luck on that. Sure po ba talaga na yung J1 visa na makapag 2-year residency na ay sa next na apply sa US ay immigrant visa na po? Well, it depends now. So there is no such thing as sure because the only entity or person who could respond to that is your employer. So example, if you are already so kung umuwi ka na dahil nga you are trying to comply with the 2-year home residency requirement, sa mga clients namin, what we do is ini-encourage namin yung employers nila to start the green card application such that while they are waiting for 2 years in the Philippines, pagbalik nila, approve na yung labor certification, and then we are now ready to get the green card approved. Now, if your employer have not started that, then there is no way for you to come back on a green card visa. But it's not too late now, right? You could basically send them an email to say, hey, can you start my green card application while I'm actually complying with the 2-year home residence requirement. Or since dahil nga ang labor certification could take at least 2 years, you could basically come back on an H1 while ongoing yung green card application mo. Yasin, is it true that to apply for a teacher as a J1 visa is only up to 55? No, there is no age requirement for the J1 visa. So for as long as you would pass the interview with the employer, you could basically get your J1 visa. So to use age as is quite discriminatory, especially for the J1 visa teachers. Amy, attorney watching here from Labason, Zamboanga Norte. Hello, ma'am. Hello po, paano po yung process ng green card holder po anak ko at nagpakasal po siya ng BF niya na may tourist visa dito sa US? Gaano po katagal? Okay, so ma'am, since current yung F2A category ngayon, the F2A category are the spouses and unmarried children of a green card holder, and yung asawa niya still in lawful status, they basically could apply for the green card now. So again, since sinabi ko na current pa naman ang category na yon, so they actually follow generally in terms of timeline yung waiting period ng mga US citizens. So the cases we have been accepting, nandun pa rin yung after you file the green card, within the 3 to 5 months, nakakatanggap na sila ng work permit, and at least they will be able to get the US Social Security number and be able to work. And then, normally the interview happens on the 9th month or after a year from filing the green card application. So again, to answer your question, if the spouse is still in status, meaning to say they are on student visa or a tourist visa, and they were able to maintain that, they could file the green card application now. 2 to 3 months to 5 months, they could get their work and travel permit. Then the interview for the green card could happen between 9 months to a year. But if the spouse is already out of status, then I would recommend that the petitioning spouse would wait for the citizenship kasi only US citizen spouses can cure unlawful presence or unauthorized work. So at least hindi sila magkakaproblema sa green card interview. Edwin, sure po ba? I think nasagot ko na yan. Zidig. What are the requirements for employer hospital for a nurse to wait to be able to petition her? Is it true that once filed, even though the result is not yet released, the person can already stay legally in the US if she's holding her? Okay, so what are the requirements for the employer hospital for a nurse to wait to be able to petition her? So don't worry about the employer requirements though, because once the employer is interested to filing a nurse petition, this is basically an immigrant visa petition, the lawyer will communicate directly with them. No? So there's a lot of things that the law firm or the lawyer should discuss with the employer na hindi naman kailangang malaman ng beneficiary. So if you're, again, I'm not so sure yet if nasimulan o na employer na ba yung asawa mo, but if you don't have, if your employer is new to this, you could basically refer your employer to an immigration lawyer so they would be able to answer that. So again, just to answer your question, don't worry about the employer requirements. Kasi kung ang employer naman legitimate, then there is a big chance that they would qualify. So there are only two aspects that US immigration look into for the employer side. Una, that the employer is legitimate, that they are actually having a business permit, that they're duly registered in the state where they actually operate. And then the second one is the financial ability to pay. So then the lawyer would be able to get their financial documentation and assess whether or not they would qualify. So assuming that those two requirements are complied with, then the scrutiny goes to the applicant. And your since the applicant here is a nurse, so basically minimum requirement, they should be NCLEX passers. So there are cases where the applicant doesn't have the state license yet, but it's okay. You will be able to actually get that or complete that once the visa is approved or as soon as meron namang mga license endorsements, right? So, pwede mong gawin yun. So, the second question, the other component of your question is it true that once the I-140 was filed, kahit hindi pa siya approved, the applicant can already stay in the US if pending na yung green card application? Yes. For it's not the I-130 filing that actually give them the privilege to stay in the United States. It's actually the filing of the green card application. So ito yung sinasabi mong adjustment of status, no? So there are cases where the I-140 will be premium process, meaning it can be approved in 3 weeks. But even if it is approved, that doesn't give the beneficiary the right to stay in the United States lawfully, kasi it's actually the green card that allows them to do that. So, again, just to answer this question here, for as long as the green card application has been filed on time, then you could the beneficiary and their spouses and unmarried children could stay in the United States lawfully until the green card application is approved. But the recent trends nowadays with USCIS is that if kunwari tourist visa holder ka, nag-apply ka ng green card application mo, to actually apply one extension first, kasi USCIS is very good at sending requests for evidence now to say, hey, were you able to maintain status? And to be on the safer side, we really recommend that the tourist visa holder apply for another tourist visa extension before they actually file the green card application. So, since this is an employment-based petition, I know that your spouse is represented by a lawyer. I would recommend that your spouse contact your lawyer or your agency's lawyer and ask clarification or guidance on that. Lisa, derivatives at the time of filing I-140, sila lang ba ang covered ng CSPA Act? Yung mga added na derivatives upon receipt of welcome kit, hindi na ba sila covered? So, again, when you say added derivatives, you are actually referring to the additional. So, halimbawa, pending yung application mo, nanganak yung beneficiary, and so on and so forth. To answer the question, yes, they are still covered by the CSPA. So, the chances of them being covered are being part of the original petition, mas mataas pa kaysa dun sa una, no? Kasi again, the CSPA calculation is complicated. You really have to deal with either you have two options, right? There are avenues in online that you could actually use to assess if they are still they could still benefit CSPA, or you could consult an immigration lawyer to assess if your child is still eligible for CSPA. Don't worry about the additional beneficiaries. Ibig sabihin, yung mga anak mong isinilang later, there is a big chance that they are part of that application. You have to worry about the original children kasi nga sila yung nag-age out. So, example, if the original petition was filed by a sibling, this is the F4 categories and the processing time is 23 years, kahit na kakasilang pa lang nung anak mo nung nasimulan yung application mo, chances are baka nag-age out na siya. So that's where the CSPA could come in. But kung kunwari, nanganak ka the last 10 years, then pasok yung anak mong sinilang later. Okay? So I hope I answered that question now. Grace, I obtained my US visa in Bahrain. In my visa, it was not written either I'm subject to, but in my DS, it is indicated that I am subject. Let me rephrase that. In my visa, it was not written either I am subject to 212E, but in my DS 2019, it is indicated that I am not subject to 212E. So which one should be followed? Okay, so ma'am, may mali ka lang siguro dito, no? So what you are trying to say, in your visa, it says you are subject to, but your DS 2019, you are not subject to. So the appropriate remedy is basically you apply for the advisory opinion. But if you're gonna apply for the advisory opinion now, 99% of the cases, it will come out that you are subject to. Okay? So it's mahirap yon, but depending on the lawyer who are actually handling your case, there are cases where due to this discrepancy we receive RFEs and we were able to articulate that, hey, the beneficiary actually followed the visa stamp. And again, there are other factors that you have to consider, whether or not the program is funded by the government or personally funded or funded by the employer. Then we have successful cases where we were able to transition from J1 to H1. Kasi nga, even if may discrepancy yung visa at saka yung BS 2019. But the appropriate remedy basically is to get an advisory opinion from the Department of State to really assess kung ano yung status mo talaga. But I would recommend that you consult with an immigration attorney para alam mo talaga kung anong appropriate status mo. Kailan po pwede mag-apply si mother ko ng green card? Nakapag-biometrics na po siya sa extension of stay niya, pero wala pa po balita. Okay, so boss, I don't know if you are a US citizen. So if you are a US citizen, you could basically, again, just be aware of the 90-day rule. Ibig sabihin nun, any tourist visa holder cannot change their plan within the first 90 days upon arrival in the United States. If they actually do that, then there is a danger na madi-deny kayo by reason of fraud. And if there is a finding of fraud, mas mahirap ng transition yon, no? So, but if you are a green card holder, then you basically have to do an extension of stay of the tourist visa. So, again, if you would want to discuss that, I would recommend that you talk to an immigration lawyer para lang mag-guide kayo specifically. Okay? So, the only way that your mom could apply for the green card is if you are a US citizen. Hi, Miss Vilma. Ingat ka po dyan sa Harriman. Right? And talk to you soon. Hello, Ma'am Zen. Paano po yung processing ng green card? Holder po anak ko at nagpakasal po siya sa BF niya na may tourist visa dito sa US. Gaano po katagal waiting bago magpa-green card? Well, okay. So, ma'am, again, so it really depends kung anong status ng boyfriend, right? Kasi the visa category na ngayon ng F2A, which includes spouses of a green card holder, is current. So technically, if the beneficiary was able to maintain status, pwede naman talaga silang mag-apply na ng green card here. But again, you have to look into kailan dumating yung boyfriend, kailan sila mag-apply ng license, because if there are indications that there is intent to apply for a green card during the 90 days, then it can be denied. So ma'am, pa-consult na lang ng patawag na lang sa office para mag-guide kayo. Sorry, I did not answer the timeline. The timeline, just like what I said, from the green card filing, 3 to 5 months, chances are ma-approve na yung work permit and travel permit. Then the green card interview happens on the 9th month. Kapilang ko ha, si Salila. Michelle, I'm getting married next year sa Manila. I'm a green card holder. Would like my fiancé who's living in the Philippines. Is possible to apply sponsorship for him? Yeah, as soon as you have the copy of your marriage certificate, you could basically file or start the filing of the spouse visa as soon as you arrive. Or even if nandun ka pa sa Philippines, and we could basically use your locally issued marriage certificate kahit wala pa yung PSA issued, you can at least start your spouse visa application. Now, if the beneficiary is outside the United States, the general timeline for spouses of a green card holder is about 2 years. So there is nothing much you can do about that. If you get approved at USCIS earlier, depende pa rin sa National Visa Center kung anong gano'ng kabilis. But the general timeline for spouses of a green card holder, the beneficiary waiting outside the US, is about 2 years. So Grace, sa Bahrain po nakuha ang J1 visa ko. Sa visa, walang nakasulat na subject ako. Pero sa ads, I think I answered that question, no? So, again, there are ways to, you really have to consult a lawyer. There are other factors that the lawyer needs to determine. But in terms of discrepancy between the visa and the DS 2019, the appropriate remedy is get an advisory opinion. Because it still is a risk. Pwede pa rin i-challenge ng officer handling your next succeeding applications that whether or not you are subject to or not subject to. Carlene, my question is about schools petitioning teachers for H1B. May instances po ba na when the petition was filed at first, they have not decided to avail the premium processing. However, while waiting for the result, they decided to go for premium processing from Bilis. Pwede pa ba yun? Yes. Or from the start ng filing application, kailangan mag-avail? No, the employer could basically apply for premium process while the H-1B application is pending. Z, asking on behalf of a friend who is a J1, if you have a court document against your spouse on the grounds of violence against women, and could that be a strong document for a waiver? So I would not say it's a strong argument on its own, but it can be used as an argument in the case. Kasi when you apply for a waiver, especially for the exceptional hardship waiver, the general rule is you look into the totality of circumstance principle, right? So what it meant is, hindi lang isang factor ang babasihan mo. It's a combination of so many things, and then the officer will decide if there is exceptional hardship. Ngayon, if one of the argument is to say, I cannot leave the US because I have to attend court processes because I filed a domestic violence, then that could be a reason of increasing your chance of approval. But that alone is not enough. So it really depends on how the case is being presented. But to answer your question, it can be used as one of the factors, not the only factor to win an exceptional hardship waiver. Ria, attorney, what happened pag namatay na ang petitioner? What? So, just like what I said, the petition dies with the petitioner, but then you can look into the humanitarian reinstatement as a way to revive the application. So, you can actually go to uscis.gov and then just type humanitarian reinstatement. Tuturuan ka naman doon anong requirements, saan i-file, anong timeline, but there is really no timeline for humanitarian reinstatement. You could basically wait for years before it can be approved. Gonzales, attorney, if hindi po ba sa Pinas ang 2-year residency, makakabalik po ba sa US as J1 after 2 years? So, then again, the rule kasi is very clear, no? So, if you obtain your J1 visa, you have to complete your 2-year home residency requirement either in your home residency, which in this case in the Philippines, or kung nakuha mo nga siya sa abroad, Thailand, Indonesia, you can go back to those countries and comply with the 2-year home residency. So, for process of conversation, halimbawa nga, no, nakuha mo sa Bahrain yung J1 visa mo, you cannot go to Canada and stay there for 2 years and then hoping that the embassy would be able to approve that. So, that's not within the rules. So, you really have to make that decision whether you go back to the Philippines or you go back to the country of your last residence to be able to comply with your 2-year home residency requirement. Maria, good morning. Is it possible po ba na ma-approve pa rin kahit ma-denied na? What is the difference between denied and dismissed? Okay, so I'm not so sure if this is a case pertaining to immigration, but I would presume in the context of immigration, I'll try to understand what the question is. Na? Is it possible po ba ma-approve pa rin kahit ma-denied na? Well, it depends. No? It depends on anong klaseng application ba to. Is this a tourist visa application? Is this an immigrant visa application? And either of those, it depends anong ground for the denial ba. So if the ground of the denial is the lack of supporting documentation, then you could basically apply again and make sure that you provide the missing documentation. But if the ground of the denial is fraud, misrepresentation, or criminal records and all that, then you have to have a waiver. So I would recommend na mag-consult ka ng lawyer to really understand what your remedies are. So the next question is, what is the difference between denied and dismissed? So in immigration cases, there is no such thing as dismissal. There is only a refusal and a denial. So if you could basically follow up that question, because I don't see that context in the context of immigration law, yung second component ng question mo. So again, if it's a denial based on the lack of supporting documentation, then it's a lot easier, right? You just have to file and provide the supporting documentation. But if it's worse than that, because there's criminal record, there's misrepresentation or fraud, then your remedy is to apply for a waiver and refile. No? So again, I haven't come across a case in immigration where the case is dismissed. Okay? Thank you. Annie, if nandyan na po sa US as tourist and if may nag-sponsor po work as a nurse, do I need to go back home to Pinas and I will wait an immigrant visa? Not necessarily though, right? So again, just remember about the 90-day rule. If the beneficiary is already in the United States beyond the 90 days and wala naman talaga silang intention na when they first came in, na hindi na talaga sila uuwi and so on, then to answer the question, is it possible to transition from tourist visa to waiting for the I-140 or the green card to be approved? Yes, you don't have to go home if the potential employer already has an approved prevailing wage. Pero kung magsisimula pa lang siya, then you have to find a way to be able to extend your stay. So again, I would recommend that you talk to an immigration lawyer to explore your options. But to answer your question, yes, there are ways that you could extend without having to go home and wait for your green card to be processed here. Hello, Sir Ricky. Sir, mas maaga pa, boss. Tulog ka muna ulit, no? Good, hope to see you soon. Tans, Attorney, am I qualified to have a tourist visa just to attend my first degree cousin? His graduation is May. He's yet to grad. Which visa should apply? I'm a nurse po. I might have a chance of denied. Okay, so boss, applying for a tourist visa there is a 50-50 chance to anybody, right? So it doesn't matter if you are the most popular, mayaman, or a normal person, ordinary person in the Philippines applying for the tourist visa. So again, discretionary kasi yung tourist visa, no? So una, for as long as the officer feels like your intention of coming to the United States is temporary, then big check ka na doon, no? So halimbawa, attending a wedding, or visiting friends, or just basically visiting the United States are approved purposes of a tourist visa, no? But if you actually notice, you've heard from your friends, your neighbors, or relatives who are actually being denied simply because even parents get denied na ang reason nila is mag-attend ng kasal ng anak nila, no? Because then again, a tourist visa is maraming factors discretionary siya, no? So it really depends on the interviewing officer on that day, kung anong nakikita niya sa applicant, kung i-approve ba niya or i-deny niya yung tourist visa application. But the bad thing is, there is no review for tourist visa application. So it means that if the interview officer denies your application, you cannot call his supervisor or her manager to actually say, hey, can you review the decision of this guy because he denied my tourist visa application? So your remedy is to reapply again. So in your situation, if the purpose is to attend a wedding, it is an allowed purpose, but that denying or approving your decision does not rest on that. But I think you are worried of the fact that you are a nurse. Marami namang mga nurse na na-approve ng tourist visa. So just like what I said, isa lang yun sa consideration no? It really depends on, at the time of the interview, what the interviewing officer or the consular officer sees in you or in your application that drive him or her to a conclusion whether you are coming back or not coming back to the Philippines after your stay in the US. So, good luck on that one. Adishina, good day, attorney. My sibling failed to file ILPINIA after 30 days. It was mailed. What to do? So, good news is there is a new release advisory by USCIS that they are actually extending flexibilities to respond to notices which include request for evidence or even filing a motion to reconsider or to reopen. So if you could actually check on flexibility at USCIS extending flexibilities to response, to giving a response to notices, then you might still qualify. So again, I don't know the reason why your case has been denied. If you are not so sure, this is what I basically advise a client, no? And then I've been accused of, dahil abogado ka, you always say, consult a lawyer. So then what do you want me to say, right? Kasi ito lang yung general rule nun. There is no doubt that in any legal cases, whether it's criminal or civil cases or in immigration cases, if you know what to do, then do it yourself. This is what we call pro se applications, meaning you don't need a lawyer representation. You can basically do it on your own, only if you know what you are doing. If you have doubts and if you are not familiar with these processes, I would really recommend that you consult a lawyer kasi there are technicalities eh. So, hindi ba, just for example, and I just want to say this, explain this in English because not all audience are Filipinos here, no? So, there are technicalities that could be involved, right? So, this is again the 33 days. If you fail to comply with that, then your case might be denied by not following those technicalities of filing on time. But there is also a remedy, what we call USIS extending remedies or flexibilities to respond. Then you might be able to basically use that. But that's only one component of responding or fighting your case. There is also addressing the ground of the denial, right? So why is the application denied? Is it the fact that you are not able to you are not able to prove that you are siblings? Because I've seen cases like that, especially in the countries in your region, right? USIS seems to be doubting relationships. I have a case in Nigeria where USIS doubted the spouse visa relationship despite the documentation that we provided. But of course, they were approved, but we fight it out. We actually give a proper coaching to the applicant. We encourage the US petitioner to go back to Lagos and attend the interview with the husband because, again, there is that tendency that the scrutiny is there. So, again, my recommendation, Adishina, is that you consult a lawyer so you know. But to answer your question, if you go beyond the 33 days, there is again flexibilities in answering RFEs or notices of, or decisions, notices of denial. There are additional 60 days from the 33 days. But again, that's only one aspect. You still have to address the ground of the denial. So good luck on that. Ellen, J1B waiver case is pending. Pwede po ba mag-apply ng 485 while waiting kahit out of status na or any kind of visa na may i-apply? So, this is interesting though, right? So, the J1 waiver is pending. Pwede po ba mag-apply ng 485? Una, as a lawyer, we don't file the 485 kung, again, it really depends on kung halimbawa, if I'm representing you on a waiver, I have a way of trying to take the risk of what is my chance of approval, right? So if I believe that the waiver arguments are strong, though the general rule for J1 waivers is that you have to wait for the waiver to be approved before you have the green card, you can file for the green card, right? But it also depends, right? If you are applying for the green card based on employment, then generally no employer will file for your green card if you're already out of status. Because during the interview, your green card application will be denied, not solely because you don't have a waiver yet, but because of the fact that you already out of status. But if you are married to a US citizen spouse, then your being out of status is not an issue because it will be forgiven for the fact that you are married to a US citizen. Now, so let me answer the two aspects of your question. Even if the J1 waiver is pending, can I apply for a green card application? Right? Again, it depends on the what is based on the assessment. What is the chance of your waiver being approved? So again, there are cases where the green card application being approved, even if the waiver has not been approved yet. But if the green card application is based on employment, I don't recommend that because it will still be denied. But if the green card application is through family based because you are married to a US citizen, then yes, you could file the green card application even if the waiver is pending. GSAR. Applicant po ako before ng J1 teacher. I already have my NMP teaching license and my credential will evaluate OS and was sent to the address of your processing agency. Unfortunately, agency was now closed and don't have a copy of the West results and pertinent documents required. I still have the chance to apply for H1 visa and secure my transaction to be one of your teacher. Okay, let me analyze this. Okay, so you already have your New Mexico license, but you submitted West. So which agency are you talking about? Is the agency was now closed and don't have a copy of my West. So if I'm not so sure what agency you're referring to that is being closed, but if you are referring to the the foreign credential evaluation result, then mabilis lang naman kumuha ng foreign credential evaluation, right? So if that's what actually worrying you, una, you already have the license. And I really hope that you have the copy of the FCE. Okay, so can you still get a chance of getting a visa H1? Of course, yes. But the employer might require a copy of your foreign credential evaluation. So if you're referring to the agency, yung agency, but West is still open though. Ano yan? I don't understand the question. Can you clarify that? Which agency are we referring to? Kasi for H1B visa application, I think you already have the documents. I would look for an applicant, right? So you have your New Mexico teaching license, you have your FCE, then your other credentials. So then if that is the case, you could qualify for H visa. So pakiklaro lang kung anong agency ang sinasabi mo. I'm not so sure about what you're referring to. Mildred. May job order na ako sa Alaska. Ilang months ang H-1B visa process and how many years po makapagtrabaho as teacher in the USA? So if you already have a job order, the H-1B can be processed in 3 weeks. The labor condition application can be done in 2 weeks or even 1 week. Again, I'm just talking about published processing timeline. So there is a possibility that your case will be approved earlier than the normal timelines. Sometimes it could also be extended because you receive the request for evidence. But generally speaking, if you're going through the H-1B process, the labor condition can be approved in 2 weeks. Then if premium process yung I-140 mo, it can be approved within 3 weeks. There are cases where they are approved in 5 days or 6 days, 7 days. Again, so many factors, right? So that's how fast it is to be approved. Now, once it's approved in USCIS, it will be forwarded to the embassy if you're outside the United States. Then there is also what we call the expedited interview because of business needs. So looking into that, you could basically start the H1 process from 2 months or 3 months. You could already have a schedule at the interview at the embassy. But now, if you are located in the Philippines, once your H1B is issued, this is where the POAA requirement comes in to obtain your overseas employment certificate or the OEC. So that process could take additional 6 to 8 weeks. There are ways to shorten that. What we normally do with our employer is that as soon as we start the H1, we will now start documenting or completing the process of the OEC. But again, it really depends on the lawyer handling your case. But there are ways to reduce that. To answer your question, so again, within 1 to 2 months, your H-1B will be approved, and you could potentially be having the interview at the embassy. It's the question of if you are in the Philippines, how long the OEC will be issued. Okay? Again, balikan ko lang, how soon makapagtrabaho? Well, as soon as you have the OEC, you can fly to the United States and work for your employer. So, my J2 child will graduate high school on the year my 5 years in. If she gets to a college, ano dapat gagawin ko? Then, you could basically submit a waiver to the Department of State asking them to serve as the interested government agency. Most of the successful cases where mag-turn 21 na yung anak mo but you still have 2 years, 1 year left on your J1 visa, and you can argue na, hey, wala nang kasama yung anak ko if they wait in the Philippines, and we will be able to financially support his or her education, then there is a chance that you will be approved, right? But if you're already on the 5th year, again, I'm not saying it will not be approved, but it could be a challenge now. So, but to answer the question, you can apply for a waiver through the Department of State, asking them to serve as the interested government agency, and then argue your case why it is necessary that your child needs to stay in the United States pending your J1 visa validity, and good luck on the approval. But there are cases that's been approved, no? For as long as you could basically articulate your case. Follow-up question, pwede ba sabay i-file I-140? Yes. Again, forget about the I-140, no? Kasi you file your work permit, your travel permit, with the green card because it's the green card application that gives you authority to stay in the US legally, not the I-140. So again, the I-140 is the basis of the green card application, but again, the I-140 could stay 6 months, 9 months. The I-140 can be concurrently processed with the green card. what I'm just trying to say is when you talk about travel permit or work permit, do not associate it with the I-140. It is associated with the green card application 485. Okay? I mean, sa pagkakaintindi ko po a while ago, correct if I am wrong, please. If J1 tayo, then while waiting for residency 2 years in Philippines, the employer can file the green card pag gusto nila. Hindi na dadaan sa H1, yes. So, as a matter of fact, yung mga clients nga namin, halimbawa, no, yung client namin, nasa J1 visa sila, and uuwi na sila sa June. December pa lang, we are already able to convince the employer to start their green card process kasi nga it could take up to 2 years. So, again, yung process na yon could take 2 years, maraming gagawin yung employer, including the advertisements, right? And sometimes there are delays in completing these tasks. So even if nasa labas ka na ng Philippines, they could start the green card application anytime. In our cases, kahit nandito ka pa, assuming nandito pa yung aplikante, we could basically start the green card 3 months, 6 months before they leave the country. So again, to answer your question, yes, you are right. The green card application can be started while you are still completing your 2 years home residency requirement. We returned in the waiver, K1, okay. So, I don't know how to pronounce your name, but I'll just read the question. We turned in the waiver K1 visa last March through your help po and received NOAA after 2 weeks of filing. Tanong ko po, 8 months na po kaming waiting. Sa tingin niyo po, ilang months po ako bako pag mag-NOAA 2? So, again, because hindi ko waiver K1? So, meaning there is a ground of disability. Again, I don't want to discuss your case publicly, right? But you raised this question publicly. So, I'm not so sure if what is the ground for the waiver then? Because you don't normally file a waiver with a fiancé visa application. So, let me answer the fiancé visa first, right? So, the fiancé visa application, generally speaking, should be approved between 6 to 7 months. That is before the pandemic. But after the pandemic, again, there is no more normal processing time. I'll give you an example. Waivers normally used to be approved within 6 months. Now they are taking more than a year. So, kasi nga, so many reasons affected by the pandemic. Spouse visa applications normally is being approved from 6 weeks to 9 months. Ngayon, it's taking more than that, right? So, if the question is, based on the published time, depende kung saang office siya naka-assign, it could take 6 months to 9 months, right? And again, if you would want to know when the processing time assigned to the office, you could always ask naman the staff assigned to the case because they will be able to give you the processing time. Now, so if your case is beyond processing time, normally internal process namin is to escalate your case. What is not so clear to me though is when you said a waiver K1 visa. What does that mean? You only file a waiver if there is already a prior denial in your case. Okay? I don't intend to discuss your case publicly. But we are relatively good in waivers. I just don't know the ground of the waiver that you're talking about. Okay? So the waiver is another problem though, because again, it's taking more than a year to get approved. So I normally post on my social media accounts that we get approval of this waiver, exceptional hardship, extreme hardship, 10-year ban, and all that. But they are taking more than a year to wait. We often receive calls that they are frustrated, but what else can we do, right? We are not the ones deciding in waiver applications. And even if you go to the published time for the waivers, it really is taking more than a year. And there is generally no ground to expedite a waiver application. So, ma'am, if you could basically use our group chat and just explain a little bit, because I don't have your case in front of me, why we filed a waiver in your case, because that doesn't ring a bell to me. Okay? So, thank you po. Ilang years po ang usual hintayin pag over age ako, may immigrant petition? So, it depends. If your case is you are an unmarried child of a US citizen or a green card holder, normally it takes about 8 to 9 years. I mean years from the time of filing. But if you are already married, then it could take between 12 years to 15 years. So you count the filing date and then minus it from now, then you deduct, basically you deduct it from 8 years to or 15 years, then that's your waiting time. Max, may possibility pa daw ba makabalik sa US ang J1 visa holder na kapag stay ng 90 days after makat ng visa sponsor ang service mo? Okay, so your question is, if you are a J1 visa holder, so let's just say for purposes of conversation, you are given 3 years, right? But for whatever reason, your J1 sponsor cut short your visa validity, if I understand that right. May possibility po ba daw makabalik pa sa US ang J1 visa holder na nakapag-stay ng 90 days after makat ng visa sponsor ang service mo? Dahil di pa naman daw nakapag-accrue ng 180 days. Ban po kaya for 3 years. Okay. Let's dissect natin yung application mo, boss, ha? Generally, a J1 visa holder stays in the United States based on the period indicated in your DS 2019. So, halimbawa, yung DS 2019 mo, binigyan ka ng 1 year, then your authorized stay is 1 year. Pero pag binigyan ka ng 3 years, then your authorized stay is based on that 3 years validity period. But there are cases where your J1 sponsor would cut short your stay for whatever reason. And that's fatal, no? And I don't want to dig into the reason why your J1 visa is being cut off. The problem with that though is pag kinut short siya ng J1 sponsor, if you actually heard about, hey, if I'm a J1 visa holder and I completed my program, I have the right to stay 30 days grace period after my program ended. 30 days, not 90 days. Okay? But it's a different case when your visa is cut short by the J1 visa holder. Then the day after your J1 visa validity is cut short, then you are already starting to incur unlawful presence. Now, the second question is, makabalik pa ba kami ng US dahil 90 days lang naman ang unlawful presence namin at hindi siya sumubra ng 180 days? Yes, if the visa is an immigrant visa. Ibig sabihin, kung ako yung employer mo, no? And since this is a J1 visa holder, I would presume whether in the HRM industry ka or you are a teacher, if your employer was able to bring you back on an immigrant visa, ibig sabihin, green card yung final mo, yes, you can come back, but during your green card your embassy interview, you really have to be prepared to show to the officer that, hey, I did not incur more than 180 days of being unlawfully present in the United States. But if you are referring to, pwede pa ba ako makabalik on a J1 visa or an H1 or a tourist visa? No. Because you already violated the terms of your non-immigrant visa. So, to answer your question, the only way you could come back to the US, even if you already incurred unlawful presence of 90 days, is through a green card immigrant visa process. So, I would recommend either maghanap ka ng employer that could start your green card application or convince your employer to start your green card applications para hindi ka magka-problema pagbalik mo. Good luck on that, Max. Julieto, my Jito son gets married to a US citizen. Would it be possible he can process and gets approved to become a green card holder? Yes, but they need to be approved of a waiver. And since J2 siya, the J2 applicant cannot directly apply for the waiver. It has to be through the J1 visa holder. Dayan, thank you for being part po ng aming immigration journey. Yung advice po na nagawa na namin, finally able to find employer to petition us under AB3. Now I have an AED awaiting for sa green card. Oh, okay. Ma'am, thank you po. ID. Hello, ID. Hanggang kailan po current yung status? We really could not say because it changes every month. So far sa ngayon, current pa rin yung spouse of a green card holder. So, if I were you, ID, take advantage of that. Again, the only factor that could stop you from doing the filing of the green card is kung ano yung unlawful status ng beneficiary. So, again, I would encourage you that you schedule an appointment with us. I don't want to discuss your case publicly. Okay? Mayli, I am over 21 when my mother petitioned me. Ilang years po kaya ang hintayin bago dumating? So if you are still unmarried, just like what I said a while ago, it could take 8 years from filing. Zap Jen, good evening. Is it possible if tourist visa, then magpakasal sa US? How long po dapat magpakasal since pagdating mo sa US as tourist visa holder? Okay, so if you're coming into the United States on a tourist visa with a plan in mind that you are going to apply for the green card, then that's fraud. Okay? But are there cases where pumasok ako as a tourist visa holder, then there is a change of plan outside of the 90 days, then you apply for the green card? Yes, but you have to be very, very careful with that because there's a lot of ways that the officer could catch your intention. And if that happens, then there is a risk of fraud. I recommend that you consult with a lawyer so you will be guided accordingly. Tony, is it possible to transfer J1 waiver to EB9W after getting your waiver? Okay, so is it possible to send J1 to NIW? Okay, maraming nagko-consult sa akin dito no na hey, can I apply for the non-interest the national interest waiver? So just to briefly discuss hierarchy of waivers, right? So the national interest waiver is a very high level. I'm not saying Tony that you don't qualify because I don't know the details of your circumstance, right? The national interest waiver is a very high level category. You could basically apply for the green card application through the national interest waiver. I have had cases on national interest waiver which was been approved after 9 months and the applicant obtained his green card in 9 months. So what is a national interest waiver then? So this type of waiver is basically approved for the most distinguished applicants because they have received either domestic or international awards, right? So they basically is the best in the state. They are the outstanding this and that, right? But it has to be sustainable though. If you're gonna apply for the national interest waiver, then you should be able to articulate what is it for the United States. Okay? So, halimbawa, the latest case that I was able to get approved to is he's an architect and he plays a very important role in bridge building, right? That if the national interest waiver will be approved, then their company will not be able to finish their government contracts in completing or maintaining established bridges in the United States. So that's how we argue the U.S. interest part of the NIW. What is the other NIW that I got approved is he is a chemist, and I have no doubts if in the next few years he would qualify for the Nobel Peace Prize, right? That's how high the NIWs are. But people often confuse with, am I eligible for NIW or for the O1 extraordinary ability? Because their requirements is quite similar. For the extraordinary ability, though, you could still petition yourself, or the most common cases is you would need an employer to be able to petition for your green card. So again, even on a normal consultation on the NIW or the O1 extraordinary ability, one session is not enough because you have to satisfy 3 out of the 9 uh, criteria, and you have to supplement those criteria strongly. Okay? But to answer the question, is it possible to apply for the J1 to the EBNIW? Again, it really depends on what your credentials are. If the question is it possible, assuming that you are the highest tier of that group? Yes. But I haven't seen across, again, I don't know if you're a teacher or whatever, right? I really recommend that you consult a lawyer to really assess because NIW is a very expensive waiver, right? You could basically filing a 1 foot thick application for that, and it will consume the lawyer's time. That's why I recommend with my clients though, when they are actually trying to go to the NIW application, to really at least have 2 session assessment before we even file the application, because we don't want to waste your time and money applying for the NIW and then get denied. But the other option that you could look at is the O1 extraordinary ability though, because it's very close to NIW, but in terms of standards, it's lower than the NIW. There is also the possibility that you could apply the NIW and the O1 concurrently. So at least if you get denied on the NIW, you could still be approved of the extraordinary ability. But then again, the question is, can I transition from J1 to NIW or O1? Yes, it depends on the strength of your case to qualify for the O1 or NIW. So again, I don't expect that I was able to answer that question because that is not an easy question. You really have to consult with an immigration lawyer. NIW and the O1 extraordinary ability requires more than one session to fully assess whether the applicant is qualified or not. Okay, so good luck on that, Tony. Hello, Mark. Kumusta Singapore? Talk to you later. Attorney, pwede ba after the joint program mag-work ka sa ibang bansa, din balik ka sa US under H1? So again, just like what I said, there are only two countries that you can go back to comply with your two home residency requirement. Either the home country residence, which is the Philippines, or your last country of domicile. So kung saan mo na ko yung J1 visa mo, pwede ka rin doon mag-comply ng 2 years. Okay? So, I didn't notice it's been more than an hour since we already have that discussion, but medyo madami-dami pa to. So I'll give another 15 minutes and then we're gonna cut off our session. But again, thank you guys for tuning in. Alam kong gabi na sa Philippines. It's morning here in the United States. But again, I'll try to answer the question as much as I can. Attorney Nick, si Bernadette po ito. Nag-file po tayo ng waiver K1. Ma'am, do you really would want to discuss your case publicly? Or do you want just to discuss it? Right? Kasi again, if what you're trying to say is it's taking NOAA to, then it could be for the waiver. And again, I don't want to discuss the reason of the waiver because, again, the waiver could involve criminal notices either on your part or your petitioner. It could be ugly, right? So if you would want to really have a conversation with me to discuss that, if my staff has not been giving you, because we're very transparent, right? I just don't want you to discuss your case publicly. Okay? So, ma'am, can you send me a case? If you can call me after my live to discuss that, right? Because this is a waiver case. This is not a simple fiancé visa case. Nag-file po tayo ng waiver K1 last March 2002 and after 2 weeks of filing, we received NOVA 1. Yeah, this is case receipt. Tanong ko po, ilang months po ang kami magtingin baka makareceive ng waiver. So again, are you talking about the waiver? Because again, as I explained, it takes more than a year to get an approval of a waiver. Nakikita po kasi namin na USCIS website 15 months na. So again, if it's 15 months, we have to file an escalation. And filing an escalation doesn't mean you can demand a decision right away, right? So it still depends on the officer handling your case whether to get a decision. Now, in cases na talagang matigas yung USCIS, the other remedy is to get congressional assistance where we get the congressman and the senator involved in different cases. So again, do you really want to discuss this publicly? Or you can send me a message later, or you can talk to me after my Facebook Live and discuss your concerns. Okay? Talk to you in a bit, ma'am. Pwede po ba after J1 mag-work ka sa ibang country and be back? I just want to comment on the applicants on the waivers, no? And that's the reason. That's one of the reasons why I'm not accepting new waiver applications anymore. The time to prepare a waiver is not easy. It takes a lot of. I put my real emotions. I go beyond my role as a lawyer when I accept a waiver application. I take it personally. Even after years of experience, every time that we get an approval of a waiver, we become excited as an organization because we know that we really fought for the client, right? But it is as frustrating as everyone else that the government is taking more than a year, despite their published publications, despite us escalating their case, and there is no direct response yet. There is nothing wrong with the applicant, with the law firm, or with everyone else. It is just the processing time. And there is no ground to in real reasons, expedite a waiver application unless it is a life death situation. So what I'm trying to say, and there are cases where we have that hey, if you don't escalate this, my petitioner spouse will die in 6 months because they have cancer and all that, right? So in that case, you have a better chance of getting approved of a waiver, right? So again, I have represented more than hundreds of waiver applications, and they share the same sentiments that hey, why is it taking time? We share the same sentiments that it is taking the government more time to that. We do our best to escalate. We do our best, if necessary, to do congressional assistance, right? So, ma'am, I really recommend that you talk to me after this Facebook live, right? Kasi nga, I just don't want you to publicly, openly discuss your case because we have confidentiality clauses. You basically, I mean, you didn't discuss close, fully disclose your name, but don't discuss it in a public, ma'am, right? Because I will be forced to defend our position, right? And I don't want to be placed in a scenario dilemma where I could be sharing your personal information to hindi na siya win-win situation for you and for me, no? Okay, just send me a message and we'll talk after this live. Okay? So it's already 1 hour and 21 minutes. I still have 9 months to complete this Facebook live. And again, thank you. Yasin, if you're applying for the NOS and waiver, then it is denied. Is there a possibility that you apply for J1 or H1 after 2 years? Yes. So if your application for the no objection statement or exceptional hardship is denied, so there is still another remedy that you could actually go through, which is basically the motion if or the appeal. So example, if your no objection statement is denied at the Philippine EVP, then they actually had this mode of appeal. No? But if all that fails, so even in the exceptional hardship and your motion to reconsider or reopen is still denied, then you basically could forget about that, uuwi na lang ako, comply with my 2 years, and then just wait for my 2 years to be complied with, then you don't worry about waivers anymore. And to answer your question, yes, you can come back on H. Even if you can come back on a J1, I would not encourage you to get a J1 because you might go back to the same scenario 5 years later. So I would encourage you to apply for an H visa or convince your employer to start your green card application. Okay, Alvin, what could be the factors that H1B visa petition could be subject to RFE? The common ones were generally is they would challenge us that the position offered is not a specialty occupation. So I'll give you an example. If your petitioner is applying for a general manager position, then chances are they will ask, you will receive a request for evidence. How is a general manager a specialty occupation? So there was a point in the past where the nurses fall into the H1B, but nowadays you cannot file H1B for nurses, registered nurses, because USCIS argued that it is not a specialty occupation. Of course, we know it is a profession that requires specialization and so on. So what they are saying is you can apply for H1B for an ICU nurse or a dialysis nurse because that's more specialized, right? But so then again, that's one factor that we normally get an RFE on. You are being challenged on the specialty occupation. That's a lot easier to argue. The second one is the licensing requirement. So there are states, and actually most states require applicants to get a license before their H1B can be approved. But in most cases, it's very difficult to get a license because most states require a social security number. So again, you could still obtain an H1B visa, but you need to articulate or get a certification from the state that I cannot proceed with my license because a social security number and or a visa is required before we can proceed. So that you can also be a possible area for your RFE. And then the other thing is the ability to pay off the employer again because they have petition that your income is only this. Then we normally work with the employers to get their latest audited financial documents. The other reason why you get an RFE on the H1B is basically on the depending on the cap exempt status. If your employer is claiming exemption from the cap exemption, then they normally ask that, hey, give us documentation why you believe you qualify for the cap exempt. So those are the common ones There could still be other reasons, but that's very rare. Michelle, sa interview po ba na F11, what are the chances of being approved? So, family-based petitions though, generally, what they are inquiring into is basically the relationship. So, for as long as you would be able to establish the legitimacy of the relationship, whether, again, I'm just talking about family-based petitions in general, whether it's a spouse, a child, or a sibling, then you should be approved generally. The other reason why you get be denied though is if the beneficiary has criminal records or if they had misrepresentation or fraud incidences in the past, no? And the other reason is ability to the affidavit of support. So it's possible that your petitioner cannot support you financially. In that case, they can look for a co-sponsor. Okay, so I have 4 minutes left. So I cannot answer all questions because there's still a lot, but I will just maximize the time I have online. So GSAR, ang agency humawak sa credit namin and it was already closed. This is your follow-up questions, right? So, TTSI, I presume, is a J1 visa sponsor. So, kung hindi na sila available, boss, then find another sponsor. So, if you are saying that you are basically asking our agencies to help you out, then my agency would be able to help you find an H1B employer potentially. But the hiring season is potentially starts in January, generally speaking. So, good luck on that. Don't worry about TTSI anymore if you are going through another H1B application. Alvin, what could be the factors that each application could be denied? I think I answered the question. I have a petition number for an H1B, but my application is being RFE'd for lack of district teaching license. So again, just like what I mentioned a while ago, that's one of the common reasons of receiving RFEs. Yasen, if nag-apply ng J1 waiver, need din po ba mag-apply ng J? No. Once the waiver for the J1 is approved, it includes automatically the J2. Anthony, if I am a teacher under J1 visa, can I apply for an EB2 in IW? I think I answered that question. If si derivative na beneficiary ng CSPA ay hindi ma-issue ang visa due to grounds of inadmissibility, moving pa ba? Okay, so again, on a CSPA application though, every day counts, right? Kasi the reason ka gumagamit ng CSPA is you would want to make sure that at the time of the date na mag-enter in the United States yung anak mo. So again, there are cases where at the time of the interview, the beneficiary will be 20 years old and 11 months and 29 days old as a resulting factor calculation ng CSPA mo. The US Embassy fully understands that and they will actually facilitate issuing the visa so the beneficiary could fly immediately and enter the United States before the 21st birthday. So, what I'm trying to say is every day counts for the CSPA applicant. So, kung mayroon kang grounds of inadmissibility, so every day na hindi mo ma-comply or makuha mo yung waiver mo because there is inadmissibility is a day less for your ability to enter the United States. So, whatever that inadmissibility means or is, make sure that you address that immediately such that yung timeline mo is make sure na yung beneficiary maka-enter na sa US before the 21st birthday based on the CSPA calculation. Hindi siya frozen. Again, it tuloy-tuloy siya. Hanggat hindi ma-issue, hindi siya maka-enter into the United States, yung 21 days calculation niya nagka-count. Anthony, good morning. If I am a J1 teacher, would you recommend apply? I'm not so sure what the questions are. Okay, 1 minute left and I can only answer 2 more questions though. I have a same-sex partner for 10 years and applying for US job. Possible po ba na makuha ko siya even though we are not yet legally married? Una, you have to be married for the same-sex partner to be qualified as a derivative, right? Because there is no such thing as common law relationship in the United States. So to answer the question, if you get your H1, you can get married in a country that allows same-sex marriage or you can get married now while your H1B is on process, then i-add mo na lang siya as beneficiary. But you have to get married first before that could happen. Angel, I have a petition under H1B visa, but my application is being RFE for lack of, again, I think I answered that question. I'm a G1 teacher in my fifth year. I want to know if it's possible to apply for EB2 while you are processing the waiver. Sir, I applied that. You're from Colombia. I really recommend that. Getting a waiver from other countries, though, is a lot easier. So, one of the countries that's very hard to get a waiver is the Philippines. So, again, I would recommend, Anthony, that you consult a lawyer because it's a lot easier to get no objection statement from other countries. So send me a message if you want to explore that, because again, we could potentially represent you an IW as well. But again, if the NIW is not possible, you can also look into the extraordinary ability. Yasen, regarding green card sponsor, if your employee is willing to sign only but does not want to do unnecessary tasks, it will be very hard because the lawyer will not advertise for the applicant. There are things that the employer needs to do, right? I mean, the lawyer cannot be part of the interview process because going through the labor certification is to prove that no other U.S. citizen or green card holder available to perform the job. So once the job is posted and there are other applicants, then they have to show that they contacted that applicant, that they interviewed that applicant, and it didn't. That applicant didn't get the job offer, right? So to answer your question, ma'am, it's a very hard. It's very hard to work with employers na who would only say, "Oh, I will only sign, but I will not do the rest." It will be a uphill climb for both, for the three partners, either for the applicant, for the employer, and the law firm. So, guys, last na lang talaga. Sorry, namamaos na yung boses ko. No? Asking for a friend, she's a green card holder who went home to the Philippines in 2018 but nabutan siya ng pandemic at di na nakabalik sa USA. Is there a chance? Yes. They could actually apply for the returning resident visa. So, again, guys, marami pang questions na nakapila but unfortunately, na medyo namamaos na ako, right? I just had a dental surgery yesterday. So I'm so sorry if I can cut short of this session. But again, thank you very much. And until the next time that I have my Facebook Live. And again, thank you for tuning in. Have a nice weekend, everybody. Bye-bye.